of great importance right at the beginning. Remember, you only have the 35 days to do the reckless lending in terms of.
Tim, it seems we have lost you there. Let's just have a quick look and just have a quick look and see if Tim can just get back on us. If he's based in Johannesburg, it's more than likely a power-related issue. So give us 1 second.
Guys, I don't know if you can. I'll just continue here.
Yep, you're now back with us, Tim. Go for it. Yep, you're back with us, Tim.
100%. And what is important is that you must perform an assessment. You can't just go and say, we think it is reckless. Guys, I'm just going to, just in case it's using the board badly.
Tim, what I also just wanted to ask while you just getting your connection sorted out is, I think, when we're looking at the reasonable, can you maybe just give us some more indication? Is this suspicion something that needs to be perhaps put forward prior to the investigation, or is this more along the lines of the suspicion being put forward when a recommendation is made to court?
There's a lot of case law, and there's some case law going back into the 1800s. Not only in South Africa but all over the world, where it states that a reasonable suspicion stands to be corrected if at the end of the matter, when evidence is adduced, it's just a suspicion. It's not an allegation. So a suspicion would then be confirmed if there are no contrary evidence that has been produced, or it would be defirmed. It would the evidence will then show that your suspicion was not well founded. But that's not the issue. The issue is that you need to find a reason why you have actually looked at it, and you need to put that reason forward. Suspicion will change or not change as time goes on. You don't know, because there's always two sides to a story. So I think that's the important part around reasonable suspicion. There is some brilliant case law on it, that I can supply if you want to get into that. Okay, then you must perform an assessment. The computer software is not seen as an assessment. I know some CTA members are falling off their chairs, but the question is,
expand on that.
Yeah, I think the question is, do you know, if you are asked by a court, how was it calculated? Are you going to know? Are you going to be able to confidently say, the computer took this and did that and whatever else? Well, I surely don't know. I was involved in a matter the other day where the magistrate asked that exact question and everybody was silent. So that's just not a good start to your arguments surrounding it. And then consumer consent is required. I know a lot of guys, put it in documents and 416s and so on. But the consent is required in the NCA, the original and the 2014. It would not be required in the 2019 amendment, but we're not going to get too much into that.
Sure.
Let me just see. Why is it important to investigate? The NCA 2019 will make this compulsory. So that will probably ascend next year at some stage. So I think get into it, that you don't get caught napping. Start now and just do it maybe as an exercise. Obviously, it's for consumer protection. The consumers need to be protected against, the unscrupulous guys. We know that they're there. We know that this happens, and that's why we say that the debt counsellor is the gatekeeper. The debt counsellor needs to stand with that broadsword at the gate and make sure that reckless lending do not enter, within the consumer space. And I think that's why it's so important that debt counsellors are properly equipped to recognize it and to put it forward. Now, I know in the questions we're going to discuss the problems that the gatekeepers have got, but you know, we know that there's issues. And then obviously the industry needs to check it. We all need to keep each other on the straight and narrow. And a very good reason is that the debt counsellors get paid for it. You know, so put that all together, and I think the picture comes that it is very important that it is investigated. Now, the types of reckless lending, there's really only three. It's Section 81A, the assessment done by the credit providers. We'll get into that just now. 1B, Roman 1, that the consumer's understanding surrounding the credit, the repayment, and the costs. And in 80B, Roman 2, the debt caused the consumer to become over-indebted. So that's the most common one that we would normally find. And again, beware of computer-generated reports on the basis that you do not know what the methodology was, you know, in the calculation, and it's going to be very difficult for you to put that forward to a court.
So I think then what we
Now,
can take from that is the credit provider can just perhaps show their workings as to how they got to that. Then computer should generate it, whether it's a spreadsheet or document.
Yeah, I think you know, the law of evidence is quite clear. You know, that you need to be able to prove your case and show your calculations. I think there's a second part or a second leg to it. Will the magistrate be sufficiently skilled to understand, you know, the computer workings? I don't know. That's something that you need to keep in mind. Sure. So 81A, did the credit provider do an assessment? This is not rocket science. It's the credit bureau report. All the credit agreements are reflected there. There's a history screen on the report that shows that who accessed your report for what reason and when. And then obviously the date of the assessment is important. It needs to be within a specific time, hopefully before the loan was granted. So, you know, that's a quick check, and you would normally find that this tick box is ticked, you know, when you do your assessment. Have a quick look. It literally takes you 20 seconds, because you've already pulled the credit bureau report to populate your proposal or your capturing of the consumer. So you have it. Have a quick look. It'll be there. If it's not, then it's an easy squeezy for you right through to court. Section 81B Roman 1, this is much more complicated. Did the consumer understand the credit? Did they understand the risks, the costs, and obligations? There's no case law that I could really find on this topic at the moment. I know that there's a registrant in Strand. I don't know if he's joined us, that's running a test case. I spoke to a registrant yesterday that there's a test case in Durban running. Okay. Of consumers that just do not have the intelligence to understand. Yeah. So I wish these guys well. I think it's time that we need some direction in this, because it's very subjective.
It is very subjective. Right.
It's all about the consumer. You know, was the consumer able to understand what they're doing? And you know, these issues of IQ, language is a big thing. Education is a big thing, whether under curatorship. So, you know, there's so many different aspects under this specific section that we can dive in. And, you know, I've recommended in my dissertation that this be a topic of some deep research by scholars and students, especially in law. You know, going forward, because I think we're missing, especially in our country, we let these things slip through the cracks because we don't understand it properly.
I understand. Yeah, I think what debt counsellors can perhaps take away from this, and especially debt counsellors, is that you've got your consumer in front of you. You know, if you're talking to them, whether it's on the phone or they're sitting opposite your desk, you know, you can judge from that whether the consumer was in a position to understand X, Y, and Z in your normal discussions. So I think that's key for debt counsel to take away from you, as to say, okay, I have a sort of understanding of how the consumer is in front of me, and then does that section apply? All right, so let's go on to section 81B2.
Roman 2. This is the most commonly found. I think the latest case on this is our ShopRite case of December.
ShopRite case, correct? Yeah.
Did the agreement cause the over-indebtedness? The calculation, you use the debt review information. So when you have done your assessment, all the information that is required is there. You don't have to go and look somewhere else. And I mentioned previously the documents that everybody is requesting from the credit providers.
Yeah.
I do not believe that it is of such importance that it's made out to be. The circular that we might issue might disagree, but we'll cross that bridge when we get there.
Okay.
And I think ensure that you just double check your information. That's always important. There is nothing worse than stressing the night before when you're appearing in court the next day to present something, and you stand up and your figures doesn't match. There is nothing worse in the world than that. So make sure that your figures go, and it's a deficit or surplus question at the end of the day when it comes to this section. Look at the minimum expense norm. We'll get a little bit into that a bit later, which is broken at the moment. To be fixed, but we'll get into that. But it's really as simple as that. And there's the CASA a while back, I think in 2015 or 16, published a document on how debt counselors should approach this type of question, and I think it's still very relevant today. It's something that I actually use quite often. And the calculation is simple. It's a gross income less your statutory deductions, which you have on the payslip. There's the maintenance payment, which you'll get on a quick chat. There's the actual living expenses or the minimum expenses norm, whichever is the most. There is no substitute for the consumer's actual situation. If the consumer says, I need so much, that's how much they need. So that's always a rule of thumb. If the minimum expense norm was applied by the credit provider, if you have the documents to show that, then you can see how they got to that and how that matches up with the actual living expenses. But if you do not have that document, the minimum expense norm should not really be something that is in your way, because you have the actual living expenses. And as a debt counsellor, you would know that this is quite often queried by magistrates. So it's important to have the correct documents that if you are queried on it, that you can easily show that that is the case. Then less your existing debt repayments, and then available to repay new debt. Now, this is specifically for the last credit agreement that was granted. So when you look at your credit bureau report, you'll see which one was granted last. And all the other repayment, you would put then in less existing debt repayments when you calculate the affordability for the last one. And then you'll see what was available, then less the monthly debt repayment of the last credit, and then see if there's a surplus or a shortage. If there's a surplus, there's no reckless, and if there's a shortage, there's your reasonable suspicion. And you can easily show, during this calculation, where your suspicion come from. And it's easy to show statutory deductions from your payslip. Maintenance is easy to prove, your living expenses, and then your debt, which is on your credit bureau report. So, guys, this is really just as simple as that. Nowhere here does any documents feature, but different people like to do it in different ways.
Yeah. Tim, I think just from my side, just to also add before you move on to the minimum expense norms, is, it's with your previous comment, we were looking, you need to make sure that your information is correct. We have a lot of questions that have come up where they specifically mention, that I think there's a perception that debt counsel are perhaps a little bit scared to take on reckless spending or potential cost orders. And I think that's where that comes in. If you, dotted your I's and crossed your T's and made sure the information is correct, then perhaps cost orders won't be awarded because the information that you put forward is actually correct. I don't know if you agree with that, Tim, or if that's the perception out there.
In our view, and what we found is that this is completely overthought. What the debt counsel is trying to do is to prove that they were reckless lending and They really go out their way and take on onus that is not theirs.
Sure.
The credit provider, if you look at the Act, the credit provider needs to provide to the consumer the credit agreement and this and that. But would that really indicate to you if the consumer uh, could afford the debt or not? I don't really think so. The argument is the Act says that you need to look at it as at the point when the credit was granted. But barring a real severe change in circumstances, the consumer is going to earn more now, well, unless you're a government worker, unfortunately, than you did 3 years ago. So the chances of a consumer earning less than they did then is very little, unless there is a change of circumstances, and then it's not reckless anyway. There's an argument on both sides. But what a debt counsellor should not do is overthink it and try to prove the credit provider's case as well. That is not necessary. You need to show that there's a reasonable suspicion that the consumer cannot pay it and be able to show how you got to it. That is really as simple as that.
That's the crux.
I think where debt counselors start getting into credit agreements that they most probably don't understand, or any sort of other affordability calculations on this side and that side, they're taking on onus which is not theirs. So I think just be careful the battle that you choose. Choose your battle as a reasonable suspicion. Put that forward and say, magistrate, I need to look at this. I did look at it. This is how I did my calculations. It's easy. It's simple. It's quick to understand. And once you've created that suspicion, the onus then shifts onto the credit providers to prove that the calculations that you've made is seen out of context. That's not your onus. And when cost orders are being discussed, it's a bit, look at my calculation. There's no cooking of the books. I had a reasonable suspicion, and my suspicion was confirmed when I did this calculation. So I just did what I'm required to do. When people start rallying and jumping up and down and this and that, then cost orders start becoming a problem. But you choose your battle and don't make it too difficult for yourself. That answers your question.
The minimum
I just want to briefly. Minimum expense fund. Let's just brush briefly on that. I know that it has been corrected in the new regulation. So, but some of you didn't pick that up. Regulation 23A, go through the affordability assessment. It's an awesome piece of legislation, except for the error, and that the band percentage calculation is not linked to CPIX. I think that was a major oversight, but I think that'll be corrected. The table, have a look in the table of section 10. There's the error. The equals should be should be a plus. And if you look on your computer, the equals and the plus is on the same button. So when it was retyped, someone just didn't press shift. That's really the long and the short of it. And then band percentage calculation. When I speak to 8 different debt counselors, I get 8 different ways of how the interpretation of the band percentage calculation is. And that's because of the equals, that should be a plus. But just to give you a very quick and easy calculation, if you look at the fourth column, it's 50,000 is the max, 25 is the minimum. So you take the 50, you minus the 25, and you times it by the 8.2%. So that is 2,855 plus the minimum amount, and it brings you to 4,905.38. So it's really not a difficult calculation.
No, it's not.
I've also seen some articles. I've seen some articles where the guys are just not getting it. But if you need some additional guidance on this, pop me an email, and I can step for step take you through it. But that's really just as simple as that. It should take you literally 30 seconds to do. And don't get yourself bogged down with this. Look at real expenses that the consumer's got and expenses that you can actually prove. That's always the best way to go. Any questions on this?
Tim, no, I think that's actually, I think you've just hit the nail on the head. We've also been getting a lot of questions where they're saying, the amount of work that goes into the assessment versus the fee that's being charged, etc. But the way that you've set it out is it's, if you remain concise and you look at the information that you have before you, in any event, you're going to come to a conclusion in the first place. So I think the way that you've set it out makes perfect sense for debt counselors. So we will wait to see if there are any questions posed, and then we can always answer that at the end. But so far, I think you've covered everything on our side. Should we move on to
and I think a big part of our I think a big part of our involvement here today is the demystification, of the concept. It is a concept, let's be honest, that everybody is very weary about. People have burned their fingers. There's inconsistent interpretation by the courts. There are credit providers that have vast resources in terms of attorneys, advocates. I've heard of some senior advocates coming to court to argue matters. So it's a sticky little topic, and I think it's important that it's demystified. And the more it's demystified, and the easier you make it, the easier it's going to be for a court to make a decision on it. If you're going to smack 240 sets of facts in front of a magistrate, it's going to be difficult to get an order. So keep it simple. Just keep it simple when you deal with these things. Right. Magistrates court referral. Remember, the DC cannot declare reckless lending. They can only make a recommendation. And you can only make that recommendation when you have evidence and you can show your calculations. And that's true for anything in a court. Look at section 791B, which is quite important. Section 1 of the 2014 amendment, you can look at as well with regards to the referral. And in section 82A of the NCA 2019, that makes it compulsory now to look at it. So just go through that. I'm not going to bore you with the stuff. And it's important that it is in your court papers if you're going to make the recommendation. And that you put it in your notice of motion. We have been reviewing some matters, especially there's a matter where West Bank was involved the other day, where the court has actually not found it to be reckless because it was not pleaded properly. Now that's the last thing you want. Go and do all the work, get to court, and the court said, "Well, I can't grant it because you didn't ask for it." So I think make sure that you know what you want, put it in your notice of motion, and say, as an example, declaring the account by Piet Pompey's credit providers, account number such and such and such reckless. So make sure that you put across to the court what you actually want. You can't get a can of the best if you don't ask for it. So and also deal with it then within your court papers. Put your evidence, put your calculations, and make sure it's easy to follow. I think that's the most important thing when it comes to a referral to the magistrate's court. Any questions?
Tim, while we're on this subject, we did get a question where they asked, when you do ask for an account to be declared reckless, and we're going on to the sort of orders, and we can go to the next slide if you can, because it does speak to that. Does a debt counsellor then ask for that penalty in the actual court order together with the actual allegation itself, or is that left to another body to oversee?
Yeah, look, we call that creation of problems for yourself. You don't know how the court is going to view it. And I know of some debt counsellors that actually goes to court with 4 or 5 different draft proposals that just covers every type of order that a magistrate can make. That's a lot of work. That would probably be the best way of doing it, and with different draft orders for the different permutations. But I really don't see, even myself, if I was in practice, doing that. So I think just be prepared, and then you would have a good indication, of the papers and of your case, how strong it is. Um, and I know in some instances that the draft orders where it is completely taken off is made, but I would recommend that you wait for the court to make an order. Ask the matter to stand down, maybe to the next day or the next week that you're there, and then just prepare a proper proposal and a draft court order that then goes with the order that was made.
Okay.
That's what I would suggest.
Okay, great.
Right.
Okay, so I think, Tim, let's move over to
Magistrates
the
court orders.
magistrates can make. Yeah.
Right. So these very specific orders, 83.2, specifically with no assessment and understanding, it can set aside the whole or a part of the obligation. I do not know of many matters where that has happened. It can suspend repayment. This seems to be a favorite with the courts, where everybody is kept happy. So the repayment would be suspended on a specific account until such time as all the others have been paid. It doesn't run any interest during that time. And the consumer is then given some relief during the first payment cycles without that agreement, so the other credit providers can be paid, that was not acting in a reckless manner. So that seems to be the flavor of the week. We don't know. We check trends as it goes along, and we'll update this as we see it. And then Section 83.3, cause of overneters can suspend the agreement, the repayments, and it can restructure the repayments, in terms of that suspension.
Okay.
So there's really not, outside of this, there's not really much more orders that the court can make. They're really bound, by the provisions of the Act, and
yeah.
they would be ill-advised to go outside of that, and they cannot, in terms of our law and stare decisis. But so I think when you present your case in your court papers, see what you want, and plead that, and nothing stops you from pleading something in the alternative.
Sure.
So tell the court, I want the set aside whole or part of the obligation. In the alternative, suspend the repayments until all other debts have been paid. So nothing will stop you from doing that.
I'm doing that.
So yeah, I think that's the long and the short of it.
Yes.
I think if there's one message I can put across, is keep it simple.
I think that's what has come across, right, Tim, is that I think it's perhaps being overly complicated. And I think, from what we can take away from this is that it is simple. You have most of the information before you in any event for you to have a suspicion as to why an account should be reckless, and your investigation will then either prove or disprove that, and then you make your recommendation to court.
That's right. And like you said, it's a parallel process, whereby you would use whatever you've gathered in the debt review, and you then refer back. I mean, that becomes part of your body of evidence. If the magistrate talks about statutory expenses, I mean, that's in your proposal, and it doesn't take it. It doesn't detract from the how less complicated it is. The one just supplements the other. So use that, and do not overthink it, guys. It's not necessary. I mean, that's why the fee is 1,500 and not 10,500, because it's not. You are not putting a man on Mars. You are seeing, could he afford the last agreement? That's really all.
Sure. Tim, one of the questions that I see have popped up here is to say, if there is no, and we may have actually answered this before, is if there's no allegation of reckless lending in the court papers, can a magistrate ask a debt counsellor to conduct one, or to find an account as potentially reckless, and then ask credit providers to perhaps provide the documentation in order for the debt counsellor to do that? I have seen a couple of these myself. Is that the correct process? Should debt counsellors be fighting back on that, or sort of what's your view on that aspect?
I've also had many instances where the court papers have not, said anything about reckless, and then the magistrate takes it upon themselves, to order you to go and do that. I'm not sure if the Act supports that, but on the other hand, tomorrow you are in front of that magistrate with another matter where they might be reckless. So I don't know. Um, it's very difficult. We do not regulate the judiciary, and when we approach them, or if we workshop with them, it's very clear that they tell you that you will not tell us what to do in our courts.
Yes.
So I would advise you to do what you are told, and normally where it would come from is a magistrate would sit and actually do this simple calculation. And if
And
this simple
something more than
calculation is done,
yeah.
and they get to a deficit by just doing the first one, what is he going to think? He's going to think that the debt counsel did not apply his mind. And then you sit with a problem. If the court actually tells you, debt counselor, I think you did not apply your mind. I did not think that you are protecting your consumer as you should. So
Yes.
I suggest go back to your office, take your calculator out of its bag, and do the calculation. I think you sit with a problem. Um, I don't think a magistrate will just go and say, you know what, oh well, let's investigate reckless lending on all our stuff today. I don't think that. I think it comes from the magistrate forming a reasonable suspicion that you should have had in the first place.
Yeah, yeah. I see, now we're dealing with magistrates that are sort of ahead of the curve of other magistrates. Another question that we have here is, have magistrates been trained to deal with reckless lending? So there seems to be a perception that, you put the information forward, but perhaps they aren't equipped with the relevant information. And the only thing I can perhaps say, you can maybe comment on that is if you do have this view, take it up with the head magistrate at that local division, or in that jurisdiction that you are having this issue, and see if you can resolve it. I don't know if you are the same, Tim.
I have not received any specific complaint by any specific magistrate in the last 12 months that I can recall. If there is a trend of magistrates that do not understand, what they do, then maybe we can look at that. But if something like that is not brought to the attention of the regulator is surely not going to, know by its own volition that it's a problem. So if you pick up trends in the court, let us know, or go through your DC associations, which we engage with quite often. And let's see if that happens. Let's see. I'm not sure as to the magistrates training regarding it. I cannot comment.
You can't comment on it. That's the thing. Yeah. Tim, I see another question that has been posed here is, consumers perhaps maybe not being as upfront as what they should be. That's obviously something that credit providers will use to say, well, they were told about an X, Y, and Z. So in that case, there isn't much argument for debt counselors to perhaps pursue reckless lending. Is that the view in that regard?
You know what? I always go back to counselling must go back into debt counselling. And that's the message that the NCR is carrying out there. When you do not counsel properly, you are going into this blindly. Yeah. Questions need to be asked. You stay 45 kilometers from work, you travel 90 kilometers, and your petrol is 300 Rand a month. Now, have you counseled properly? I don't think so. You have 4 kids that's in school, and you have 50 Rand for school fees. Did you counsel properly? I don't know. I've seen maintenance that has not been made part of it at all. I've seen SASSA payments that used as income. If you start off not counseling, you're going to set yourself up for failure. And then you can't blame anybody else. Something works or doesn't. And you, as an experienced debt counselor, are trained to look for it. I mean, you through the course, you deal with consumers every day. You have a very, very specific eye. And remember, you as the debt counselor is the only one in any profession that has received training on reckless lending through the debt counselling course. So you are in the absolute best position
The best position.
to see, yeah, and it's your eye. I mean, your eye needs to pick it up, and your eye is only going to pick it up if you sit with a consumer and you really interrogate what this consumer's financial position is. Don't, many times when I have these discussions, I ask the debt counselor, how did you engage with this consumer? Now, over the phone. I said, well, how long was your discussion? About 10 minutes. What can you get in 10 minutes? You're not doing counseling. And, it's then your own fault that you did not get the information that is required. So guys, put counseling back in debt counseling, and these type of questions will disappear.
Sure. Tim, I see a lot of people are asking for precedent for a reckless lending application. Now, I think, it's very difficult to give a precedent because, it just depends which avenue you're going to go and sort of depending on the expenses and the income, the actual consumer before you. So the only recommendation I can actually make there is to check your attorney. I think there needs to be a discussion with your instructing attorney to say, look, this is what you would like to pursue. And they're going to draft the necessary paperwork. There's not a one size fits all precedent that's going to fit everything else, and that's what you put in your paragraphs, and there you go. Would you agree with that as well, Tim?
I think, let me take you back to the first few words of your question. Discuss it with your instructing attorney.
Here we go.
Now, the act does not say that the attorney needs to go and argue. And the NCR is of the view that the debt counsellor will be in the best position to put this forward. The impression, and I've seen it so many times, the impression that is created when a debt counsellor walks into a court up against an advocate, and he stands by the calculation that he's made, and he stands by his conviction that he did the counselling of this consumer properly, and this counselling indicated that that there is a problem, and the debt counsellor puts that case forward. It just makes so much more. It just got so much more power. So discussions with instructing attorneys, especially in the R1,500 fee range that you're looking at, I don't think that the legislator had that in mind, when drafting this. So, guys, you don't really need an attorney to go and put this forward. If you have an attorney going to court for you, well, that's fine. But if there's a reckless issue, go and defend your position. Go and defend this consumer, because what are you there for? You are there to put the consumer's case forward as a trained professional within the debt counselling profession. So I just needed to add that, at the start of this. Sorry, I forgot what your question was.
No. You've actually answered my question, Tim. I think what debt counsellors can take away from this is, again, sort of overcomplicating the matter. Where you have matters where you want to ask your attorneys to draft your affidavits for you, when you should just, if you've done the investigation yourself, you're the best person to put forward those facts and so I think that's the whole majority of the questions that we have is, how do they put this together? And your view is exactly how you've done the calculation. That's how you then put it forward.
I think the template would be simple. Explain your reasonable suspicion and put evidence of it in. It's really as simple as that.
Great. Tim, I think we've answered all of our questions in a roundabout way, whether it was sort of individually or through your slides. So before we finish off, do you perhaps just want to address the counsellors? Are there perhaps you want to add or recap on for them, reckless credit or otherwise?
There's a few issues, a few trending issues that we're picking up, which is very worrying, and which we are seriously looking at. The one is the current compliance monitoring that's happening. We see some of the registrants that really take this seriously and have already finished it up. There's some that is not looking at their stuff, especially the synergy between your PDA profile and your DHS profile. Guys, please take this seriously. Please put some time in it, and please get some, if you can't do it yourself, get some support in to assist you. because it's going to become very, very important going forward. You know, with especially with DHS upgraded that it's being looked at the moment. So please, guys, look at that. And then there is a major trend going in Facebook advertising, where third parties are being used to collect leads for you, and that advertising is you know, shocking. You know, get 63% off of your repayments. There's some where we have our president Cyril Ramaphosa, a picture of him, and then you know, government agreed method to get your debt written off. Guys, that is not that is not what we're there for. If you're going to start using that, you know, and I spoke to quite a few guys, and I said, well, if we're going to get a complaint on that, and you didn't save the consumer 63%, you're going to have to pay the difference. You know, let's be responsible, guys, and you know, let's put forward what we're there for. We're not there to get consumers' debt written off. That's not what we trained for. We trained for getting credit providers the money that they're entitled to. And we're giving it in a responsible manner in which the consumer can still live, make a living, and have their kids fed and have their kids at school. That's what we're about. We're not about payment holidays. We're not about free credit. That's not what we're about. And I think all of us, all the debt counselors, need to get back to basics and need to refocus on what they're there for. And I think once we do that, the reputation of our industry is going to fix itself,
Yeah.
and the consumer confidence is going to come back, and the credit provider confidence in the process is going to return. So, guys, please be responsible. You all know what your roles are, and let's play that role. Thank you. That was my soapbox.
Great. Tim, thanks so much. I think you've still got another 5 or so minutes with us. So what I want to do is I just want to go through some polls just to give us some indication. So if we look at our reckless lending poll, so we asked a question: do you pursue reckless lending in your practice? And obviously it was yes or no, and we got a 70% yes and a 30% no. So you know, it'll be quite nice to hear from those people who don't pursue it why. And we did ask a why not question. And it seems that by far majority have said that it's because consumers do not perhaps seek a reckless credit investigation. So Tim, in that aspect, you asked your consumer if he wants you to do it because he says, no, I know I owe the money, etc. Is that enough of a reason for debt counselors to not even pursue it? Or should he, by virtue of his role that he's mandated to do the investigation otherwise?
I think it's very subjective. Let me just switch this off. I think it's very subjective. You need to look at each case, you know, by itself. I think you. The first two, you'll quickly get that. And on the third, I mean, if you get and at the end of the month, and the repayments are 6,500, excuse me, then you'll quickly get an idea if it's something that should be done. You know.
Yeah. So I think what debt counsel can perhaps take away is to say, even though the consumer is saying, I don't seek it, you know, if you find that there's reasonable suspicion on your behalf, I think it's your duty to then bring that to your client's attention and say, look, this is what I have picked up, and let him comment on it. Exactly what Tim is saying.
Yeah, but aren't you then counselling? Isn't that counselling?
Correct, indeed. All right, guys, so I think there's a couple of things that we can take away from this. I think the main object is just to, don't simplify this whole process. I think it's important for you to go through these slides that what Tim has presented. We'll obviously be sharing this presentation to everybody as well. So feel free to look through it. It'll be on our website as well, and familiarize yourself with what we've gone through on these slides. And I think it would help debt counselors just to put forward what they need to put forward. simplify the matter down, and then there won't be any back and forth, I think, between credit providers and debt counselors. So guys, thanks so much for joining us. Tim, if you want to head off to your next meeting, you're more than welcome to. Thank you so much for joining us. As always, we appreciate your insight and your and everything. And I know you're very passionate about debt review and reckless lending and that. So I've no doubt if the debt counselors need any further questions, they can just pop me a mail and I'll share that with Tim, and then we can get answers back to you. But yeah, Tim, thanks so much for joining us.
Thank you very much for the opportunity. And guys, thank you for taking the time. I think it was a really important topic to touch on.
Agreed. Thanks, Tim. All right, guys. So just to have a look at our last little poll that we have, we just had suggestions on our final webinar that we want to have during the course of November. And that'll be the last webinar for the 2020 Consumer Friend Webinar Series. And you can see there, I think by far majority want to know more about Poppy. I know we briefly touched on Poppy in our last webinar that we did when we chatted to Lynn at Slipstream. And Scott raised a very important question there, is to say, well, are you actually compliant? And I think by far majority of the debt counselors put their hands up and said, yes, we are. But I think there were certain questions put forward by Scott to say, well, you know, are you still doing X and Y? So it'll be interesting to see how that plans out. So we will be chatting to our team, and we'll definitely be addressing the Poppy Am I Actually Compliant webinar series. I think it'll be a nice end. And I think it's something that we need to look at because it is on us. You know, we've got less than about 8 months or so, and then we are going to, we're going to have to be compliant. So that'll be an important series. So guys, look, that's the end for me for now. I'm going to wish you all well, and we look forward to the presidency speaking later today. Let's hold thumbs that we don't have to go and stop up and booze or anything like that. But every time from me, I just want to say goodbye from my side. Just a reminder, just to have a look on our website. This webinar will be posted on there together with all of our webinars. So if you want to frequent it, please feel free. We also have our LinkedIn page. So please feel free to go onto the LinkedIn page, follow it and subscribe to there. We'll be posting a couple of articles and videos on there as well, so it'll be easy for you to view. But like I said, we will send through all the questions that perhaps we could not get to, and we'll do a Q&A answer on spreadsheet for you, and we'll pop that through to your email as well for everybody that has attended. And then again, like I say, if there's any other questions around this, please feel free to get in contact with us, and we'll be in touch with the NCR to get some answers here for you, just to make your lives a little bit easier as well. So guys, thanks for your time, and we will speak to you at the next webinar. So please stay safe, and we'll chat soon. Bye-bye.